Welcome to another video about Australian federalism. This time I'll start by putting you on the spot. I want you to answer me. How many territories does Australia have? Time's up. If you've answered 2, you are wrong. No, Australia has 10 territories. 3 of them are called internal territories. They are the Australian Capital Territory, the Northern Territory, and Jervis Bay Territory. And there are 7 external territories. I'll put the list here on the side so you can check all of them. The question that we're going to try to answer today is what is the difference between the states and the territories? And why is it that every time we think of a territory, we either think of the ACT, the Australian Capital Territory, or the Northern Territory, the NT? What is it that makes them so special? Hello everyone, my name is Renato Costa, this is Aussie Law, and today we will look at the differences between the Australian states and the Australian territories. I reckon we should begin by opening the Constitution and reading section 122. It says, "The Parliament may make laws for the government of any territory surrendered by any state to and accepted by the Commonwealth, or of any territory placed by the Queen under the authority of and accepted by the Commonwealth, or otherwise acquired by the Commonwealth, and may allow the representation of such territory in either House of Parliament to the extent and on the terms which it thinks fit." There's a lot of information here, so I'll break it down in practical ways. I want to start by referring to the characteristics, the features that are common to all territories, including the 2 big mainland ones. The first and most important difference is that states are autonomous, whereas territories are not. We have seen before how Australian states existed prior to the Federation. They were the ones who created the Commonwealth. So they are related to the Federal Commonwealth, but they are not dependent. They are separated from it. Even if a new state was going to be born in Australia, it would still have the same status as the other states. It would be independent from the Commonwealth as well. This doesn't really happen with the territories. In the case of territories, there is a direct relationship between the Commonwealth of Australia and the administration of the territory. So territories are dependent upon the Commonwealth and the Federal Parliament. Look back at section 122. It says there that Federal Parliament will make laws for the territories that were accepted by the Commonwealth. So generally, it is the Federal Parliament that will enact the laws for the territories. It is the Federal Parliament who has the ultimate authority over territories, and it is the Federal Parliament who is ultimately responsible for the administration of the territories. Okay, you're probably saying, you have no idea what you're talking about, Renato, because the NT and the ACT both have parliaments and they legislate, they make laws for their own territories. And you are right, but just slow down a little bit, we will get there soon. But I still stand for what I said. Let me remind you of the Northern Territory intervention that occurred in 2007. Do you remember that? This whole situation was created by the Northern Territory National Emergency Response Act of 2007 that was introduced by the Howard government. That intervention was only possible in a territory. It could have never happened in a state. While the states are constitutionally autonomous, the territories have no constitutional protection against the Commonwealth's legislative powers. In that situation, the Federal Parliament overruled the Northern Territory government and even partially suspended some of the laws that were enacted by the Northern Territory Parliament. Again, This was only possible because the NT is not a state. There would be no constitutional basis for the Commonwealth to do the same thing with a constituent state. So, autonomy is the most fundamental difference between an Australian state and an Australian territory. There is one more remark that I would like to make about territories generally. When amending the Australian Constitution, Section 128 establishes a system of a double majority. I'm not going to explain this in detail right now because I'll make another video explaining the whole process for constitutional amendments in Australia. But what I want you to know is the participation of the territories in that system, because it is different from the participation of the states. In basic terms, the Constitution says that to change the Constitution, you have two steps. One vote, the first one for the majority of the people of Australia, so the whole of the people will vote. And in the second step, another vote where only the people of the states, and you have to have the majority of the people of the states to amend the Constitution. Now, we know that territories are not states, so how does this whole system look like for constitutional alteration? The other general difference, a feature that is common to all territories and a difference between the territories and the states, is that the territories, the people that are there, will only count in the first majority, as a majority of the people of Australia. They will not count in the second majority for people of the states. So this is another difference. While the states participate in both steps for constitutional amendment process, the territories just participate in the first one, counting for the majority of the people of Australia. Now, why is it that we tend to think that there are only two territories in Australia? It's because they are the biggest ones and they are in the mainland. And also because they are special. They are different from the other territories. And I'll tell you the differences between them and the other territories and the differences that remain between them as territories and the other Australian states. The first characteristic of these two territories is that they are self-governed. It's true that the Norfolk Island, an external territory in Australia, is also self-governed, but because they are in the mainland, I think we tend to think that they are actual states, but they are not, they're still territories. While the other 7 territories are administered by the Federal Department of Infrastructure, Transport, Regional Development and Communications, which is an organ of the Federal Executive, the Norfolk Island, the ACT and the Northern Territory are all self-governed. In 1910, South Australia surrendered an area, the area that is now Northern Territory, to the Commonwealth. In 1961, an act of the Federal Parliament created the Supreme Court of the Northern Territory, which was another step towards self-government. But self-government only came in 1978 with the enactment by the Federal Parliament of the Northern Territory Self-Government Act. That act also created an assembly, a legislative assembly for the Northern Territory. In 1908, the Commonwealth chose a site to become the capital of Australia. In 1911, the Commonwealth established the capital and called it the Federal Capital Territory. In 1938, the name changed to the ACT, the Australian Capital Territory. The ACT was administered by the Federal Commonwealth until 1989. In fact, in 1978, there was a referendum asking people if they wanted for the ACT to be self-governed, and they rejected it. The majority actually said no. But in 1988, the Federal Parliament enacted the law nonetheless and gave self-government to the ACT. So the ACT and the Northern Territories are self-governed, but they are not autonomous like the states. Okay, what else can we learn about the ACT and the NT and why they are so special? Why they look like a state? They are these quasi-states or super territories. Let's learn more about them. If we go back to the Constitution, back to section 122, we will see that there is a possibility for the Parliament to provide for representation of the territories in either House of Parliament. And it is because of that provision that both the Northern Territory and the ACT have representatives in the lower house, the lower chamber, the House of Representatives. To be even more precise, I should say that some external territories also have representatives in the House. Some of them do, others don't, but they are counted as part of either the ACT or the Northern Territory. The Norfolk Islands, for example, is counted as part of the ACT. You can find the provisions related to this in the Commonwealth Electoral Act of 1918. I'll leave a link to that act in the description of this video. So it makes sense for the territories to have representatives in the House of Representatives. But what about representatives in the Senate? Can the territories actually have senators? Section 40 of the Commonwealth Electoral Act of 1918 gave the territories, the ACT and the Northern Territory, a possibility of having senators. This is huge, and let me tell you why. We will see very soon that the Senate is called the House of States. There, each state has the same amount of seats, which means that they are all equally represented in the Senate. Each state has 12 seats in the Senate. So if it is a House of States, how can we say that the two territories will have representatives there as well? Because they're not states. What does it mean? I'm just going to answer this. There's a whole story behind it, and this is a real fight. Just so you have a sense of it, to solve this whole question, there was one joint sitting, the two houses of parliament sitting together, and two challenges before the High Court about that. So it is not an easy explanation, and I hope to do a video specifically about those cases later on. What I'll tell you now is that today it was confirmed by the High Court that both territories, the ACT and the Northern Territories, can have, and they do have, 2 senators each. If you don't have the patience to wait for my video explaining these two cases, I'll leave a link to them and you can read them at your own time. The outcome then was that the NT and the ACT could have senators in the House of the States. So, what are the differences between the Australian states and the Australian territories? First, the territories are not autonomous like the states. Even if they are self-governing, they're still under that chilling effect of having the federal parliament take over and override their own parliament. Number 2, the territories do not participate in the whole process for changing the constitution. They are counted in the first step as the majority of the people of Australia, but they are not counted in the majority of the people of the states. 3. Some territories are self-governed. That's the case of the ACT, the Northern Territory and the Norfolk Islands. And they also have participation, they have representation in the House of Representatives, the lower chamber of the federal parliament. And the ACT and the NT, the Northern Territory, both have senators, 2 each. Thank you for staying until the end of this video. This was an overview of the differences between the Australian states and the Australian territories. I hope you enjoyed it. If you did, don't forget to like this video, subscribe to our channel, hit that bell sign as well, and I will see you next time. Until then, ciao!